recorded live.
Well, we have a great call set up for this evening. So I'd like to start by welcoming everybody. Good evening, and welcome to our regularly scheduled 8 p.m. Eastern Time call. Before we get started tonight, I want to be sure that everybody listening into the call knows and understands what this forum is all about. This is a forum of a free gathering of people to discuss ideas. It's a group of men and women who are standing upon the land. We're here because we love America, which is one nation under God, and we're here to talk about how we can make it a stronger nation by talking about the truth. So, let me tell you what we do not do on this call. We do not give out any legal advice. We are not bar card attorneys. We are not tax accountants, and we don't give out tax advice. We are not licensed to practice law. However, if you do have a question, when we open it up for questions tonight and you'd like to discuss it and see what we would do, I'd encourage you to formulate your question in such a way that you would want to know what we would do if we were in a similar situation. And if we do answer that question, please be advised that we are not telling you to do it and we're not telling you not to do it. We're just sharing what we would do if we were in that situation. Now, if you do decide to do something that you hear on this call, or if you've heard it somewhere else on another call perhaps, or read in an email or on the internet, and you go and you decide to do that, or you pull something off the Free Americans Yahoo group, do us all a favor. Make sure that you own the information and you do not blame someone else because their process didn't work or their documents didn't work for you. If you decide to do something, you need to take full responsibility for it. Make it yours. Because if you sign it and put your name on it, it's yours. And with that said, I'm going to go ahead and turn it on over to Christian. Christian, can you hear me?
Yeah, Matt, I'm okay.
All right. You sound great. It's all yours.
Okay. Thanks, Matt. Well, welcome. I'm your host, Christian Walters. I have a show on Saturday nights called Money, Banking, and Trust by Moving Titles and Commerce, and it's on every Saturday at 7 p.m. Eastern Time. And if anybody wanted to join me on that call, it's 712-432-8773, and the PIN access number is 179441#. And you can also get that from the internet, listen off of the internet if you want, at therealpublicradio.net. So, therealpublicradio.net, all one word. And the call-in number again for that show at 7 p.m. Eastern Time is 712-432-8773. And the PIN number again is 179441#. And we've been talking about NTT, New Trust Technology, and we've been talking about trust and the Moving Titles and Commerce platform. And we've been, I think last week we talked about trustees, or the week before. So I might want to just do a little brush up on trustees. One thing I wanted to point out again was that a trustee has capacity to take and to hold title, or to have and hold, and that's the same thing that you say at your marriage vows, really. So this section really says, let me go back up here. I'm reading from Gilbert's Law Summaries, and it's on trust, and it's by William C. Halbeck, Jr.
Hey, Christian.
And it's a very cool book. Yeah.
For those of us who have the book, what page are you on?
Okay, I'm on page 33 right now, talking about the trustee section.
Thank you.
So it's under A, qualifications of the trustee, and A1, which is capacity to take and hold title. So it's talking about associations, and that says basically the whole section there is any dummy can acquire or hold trust property. And then in the next section down in number 2, it says capacity to administer the trust. And the capacity to take and to hold as above as trustee is not the same as the capacity to administer the trust. So these two sections are, the first section there, number 1, is any dummy can acquire and hold trust property, but in number 2, not every dummy can administer the trust. And it talks about incompetence, which have an incapacity and no skill and no understanding, and they lack a capacity to administer the trust. And that sounds like how they really are treating us, as being, incompetence. And it says on the next page, it says the capacity to administer an active trust, they lack that, and will thus be removed from the court and replaced by another trustee. So that sounds like maybe it was Geithner, or your current Secretary of Treasury, who was appointed trustee for the, say, the trust, or his assigns. So just kind of moving on, skimming through what we went over on page 35 there, under C, says effect of failure to name trustee or failure to name trustee to survive or qualify, section 135 there. It says the general rule is that equity will not allow a trust to fail for lack of a trustee. And at the bottom last sentence there, it says that a court of equity will appoint a trustee, and that's under the restatement of the third, section 31. So the courts will not allow the trust to fail for a want of a trustee. And the bottom of the page then, the attempt to transfer to trustee to be named in a will, where it says that trustee to be named in my will fails for lack of delivery and for want of a trustee to pass the title to at the time of the purported conveyance. So with no effective transfer, there is no trust. And basically we talked about that before, that if there is no effective transfer, there is no trust. And the next page, 36, down at the bottom in D, the nature of the trustee's interest, title to the trust res, where the trustee is said to have a bare legal title, and meaning that it is devoid of beneficial ownership, that is, the trust property is held for and on behalf of the beneficiary in accordance with the obligations of the trust. So there's your two titles, your legal title and your beneficial title in the beneficiary, legal title in the trustee. So let's see, where else? And I also have highlight on 37 under the example there, where it's talking about the settler deeds to the trustee upon trust for beneficiary for life. Does trustee have the fee or merely a life estate for the beneficiary's life? So under the modern view, the trustee will be deemed to hold in fee simple with a resulting trust that is an implied equitable reversion in favor of the settler. And under the traditional view, however, the trustee will be deemed to have a full legal title with a resulting trust in favor of the settler. So these may be things we might be able to use. Next page, 38, under at the bottom of the page under E, the disclaimer on number 1 says that normally a trust cannot be forced upon the designated trustee. Next page, he can disclaim and can refuse appointment as trustee for any reason or for no reason whatsoever. And that's restatement 3rd, section 35, section 2, subsection 2. And it's down in the parenthesis there. This probably overstates the rule. The question likely turns on harm to the trust purpose or the beneficiary who does not consent. And then the next section, section 2 there, resignation. So once having accepted, that's the key, once having accepted appointment as trustee, the person cannot merely resign unless the trust instrument gives this power or unless all beneficiaries consent. So the court has to order relieving him as a trustee, and until then he must carry out and perform all various duties, and he remains personally liable for the consequences of any defaults in the meantime. And we all go to prison as trustees, don't we? So the next section there, under A, effect of unauthorized reconveyance. The trustee cannot escape his responsibilities or defeat the trust by reconveying the trust res to the settler. The purported reconveyance may be treated as a nullity, or at most the reconveyance may effectively return legal title to the settler with the beneficial ownership remaining in the beneficiaries. The settler would then hold title as constructive trustee for their benefit. So until the court appoints a successor trustee, now the settler, as a trustee, transfers the res to the new successor once the court notifies the settler of the successive appointment. Next page, 40, removal of beneficiaries. So under 2, it says that if under the trust terms, the beneficiaries have power to modify the trust or to terminate it and compel the trustee to transfer the property to them, they have a power to remove the trustee directly because it would be pointless to require them to change the terms of the trust or terminate it and immediately create a new trust upon the terms with a new trustee. And the next page, 41, merger of title. I've been talking a lot about this. So merger of title where the sole trustee is also the sole beneficiary. So where the trustee, the holder of legal title, and the beneficiary, who is the holder of the full equitable title, are or become one and the same person, the legal and equitable titles merge, defeating the trust and creating a fee simple absolute in the trustee beneficiary, who thus holds outright and free of trust. So that works both ways to any party. Anytime that any party of the trust, the grantor, the trustee, or the settlor, or the beneficiary, hold both titles, in other words, both titles are merged into one entity, the trust is going to terminate. And the next section, number 1 down there, attempt to decline trusteeship. If the sole trustee is the sole beneficiary at the outset, it may be argued that the title merges immediately and no trust exists. Therefore, it has been said the trustee beneficiary cannot decline the trusteeship and preserve the trust, but the third restatement position is contrary to this, though. So, restatement of the third, section 69, comment D. So that's a little more modern view under the third rather than, say, the second. Okay, now that pretty much brings us up to page 43, where we're going to begin talking about beneficiaries. So section 3 there, number 3, beneficiaries. Under A, necessity of beneficiaries. Under 1, private trust. So to create a private trust as distinguished from a charitable or a recognized or honorary trust, the settlor must name or otherwise describe one or more beneficiaries. And those would be individuals or eligible legal entities. And they must be capable of acquiring a property interest, like we mentioned earlier, and becoming an obligee. And an intended trust will fail if it has no beneficiaries. And without a beneficiary, there is no one capable of enforcing the trust. So as there must be for a valid private trust, and it therefore fails. So you got to have a beneficiary when the trust is formed, because the beneficiary has to be there, and he's solely there for enforcing the trust. So next page, 44, the example tip here. So recall that a trust will not fail for lack of a trustee. However, the trust cannot exist without someone to enforce it. So thus the beneficiary is necessary to the validity of every trust except a charitable and honorary trust. So if a trust fails for a lack of beneficiary, the resulting trust in favor of the settlor or her successors is presumed. And under A, provisions satisfying beneficiary requirement. It is sufficient to satisfy the requirement that there is at least one beneficiary if there is one or more of the following. I, it says here, beneficiary is named by the trust terms, and II, the beneficiary is also described as the presently identifiable from extrinsic facts, which is evidence of extraneous facts is admissible, example, as a fact of independent significance in the case of a will. And see will summary if you want to check that out. And III, beneficiaries to become ascertainable in the future time, example, for those of my issue living 20 years after the death of X, as long as they will become ascertainable, and if at all, within the period of appropriate rule against perpetuities. Modern authority requires that there be at least one presently identifiable beneficiary. And under next one, number 1, unborn beneficiaries. This requirement is satisfied even if some, or by the better view, all of the beneficiaries or classes of beneficiaries are presently unborn. See restatement of the 3rd, section 44. Number 2, then, beneficiaries to be selected by trustee. It is even all right for the beneficiaries are to be ascertained by the exercise of the trustees or another's discretion, as long as under traditional doctrine, The class among which the selection is to be made is reasonably defined or will become so within the perpetuities period. And under next section B, the trustee's awareness of intended beneficiary. The trustee need not actually know who the designated beneficiary is, as long as the beneficiary is capable of being identified when necessary. And that ties in what I keep on saying about that no party in the trust needs to know or understand they are forming a trust, the grantor, the trustee, or the beneficiary, but it still does not negate the trust from forming as long as all the elements are there and the method of formation that the law will recognize as a trust. So continuing on, example, where the trustee is handed a sealed envelope at the time the property is transferred to the trustee, who agrees to hold the trust for a person named therein. C, the effect of lack of a beneficiary. Where a private trust fails for lack of a beneficiary or for lack of properly ascertainable beneficiaries, there is a resulting trust in favor of the transferor, his heirs, or other successors in interest. And there's a couple case sites there. So unless the consideration was paid to a transferor for the transfer, in a case site there, and another one for the trustee who paid consideration was allowed to retain property beneficially. Now, 2, charitable trust. Identifiable beneficiaries are not required for a charitable trust. The Attorney General or similar public official, say Secretary of Treasury, enforces such trust. Number 3, honorary trust. Many jurisdictions allow the voluntary carrying out, but absent a statute, not the enforcement, of the purpose trust or an honorary trust, which is a trust that are neither charitable nor private. In fact, even if allowed at all, they are not recognized as real trust in the strict sense of the term, and they are a device usually intended to allow, or generally without enforcement, the carrying out of certain objectives that are not private and that fall short of being charitable. And the classic example is the intended trust for an imperishable bequest to the one's pets. And other honorary trust purposes have involvement in the maintenance of graves, and now usually permitted by statutes, or the funding of masses, now usually a religious charitable purpose. So the example here, the testator bequeaths her residuary estate to the brother in trust to care for my dogs and cats. The trust is clearly not charitable because it is not broad enough to be charitable because it's only for testator's pets. So the contrast, a properly charitable trust for stray dogs and cats. Nor is the purpose enforceable as a private trust because there is no beneficiary capable of enforcing it. The beneficiaries are not the pets. So the beneficiaries can't be the pets because they can't enforce the trust. So A, strict view. A few American jurisdictions still appear to refuse to recognize such transfer as a trust of any sort and hold that the intended purposes fails and cannot be implemented even voluntarily by the transferee, in other words, brother in above example, who holds as a resulting trust for the transferor or the testator's heirs. The intended trust also has been held to violate common law, rule against perpetuities in its inception, as the lives in being plus 21 years cannot be measured by animal lives. So next page, page 46, the let me say with that was Lennet view. The English case here, many American decisions have recognized this type of disposition as an honorary trust, although it was not enforceable as a trust. In the case Henry Dean refused to extend the doctrine, that is for the appropriate purposes, which attempted but defective trust will be deemed to confer an unenforceable power upon the transferee to allow him to carry out the intended purpose if he is willing to do so. And as the restatement of the second, 124, and the restatement third, section 47. So in the absence of a legislation, honorary trust probably cannot last for over 21 years because of the rule against perpetuities. So number one, the effect, the transferee may carry out purpose. If, and so far, the transferee voluntarily carries out the purpose, he will be allowed to do so, and no one can object. But if he fails to do so, or after he's carried out the purpose, he holds the property, or is what is left of it, on a resulting trust for the transferor or the transferor's successor in interest. example, his heirs. In the example, some facts, as the example above, except jurisdiction applies the honorary trust doctrine, the brother is allowed to carry out testator's purpose, and if he does, testator's successors cannot complain, at least not for 21 years, or until the brother has rejected or abandoned the purpose. But brother cannot retain the property for his own use. Next, Section 2, interest created. Under the traditional view, under the traditional honorary trust doctrine where it is recognized, the interest under testators could be described as follows. The residue of testator's estate ultimately belongs beneficially to her heirs by resulting trust, subject to power in brothers to apply, if he wishes, funds only to the care of the testator's dogs and cats. B, the third restatement view, more modern view. The third restatement views brother as trustee with usually non-mandatory power exercisable for a stated or reasonable time to apply trust property for a designated purpose, and reversion in testator or successors and a right to enforce brother's administrative duties is implied by law regarding any excess or remaining trust property. Next, Section C, UTC view, the Uniform Trust Code view. Under the UTC, the transferee of the intended trust for pets, in other words, the brother in the above example, is considered a trustee with a mandatory power to apply trust property for the designated purpose exercisable until the last surviving pet dies. So all other types of honorary trusts are enforceable under the UTC for 21 years by a person named in the trust instrument or appointed by the court. Next, Section C, distinguished. If purgatory expression, example, I hope, I wish, or I request, are used, and if no trust intent is shown, the transferee can disregard the suggestion and retain the property outright. Thus, if the transferee wishes, he may carry out the transferor's suggestions, so not as honorary trust, but because he is free to do so as owner of the property. So we have to be very careful of using precatory wording and what we're expressing in the indenture or expressing the trust in our words that we choose to use, because they must not be weak. They have to be direct and command or an order. So for the example tip here, if you encounter a fact pattern now, in an exam or in real life, let's put it this way, in which the transferor purports to leave her property in trust for the care of her pets or the maintenance of her cemetery plot, think honorary trust. If the named trustee is willing to perform his duties, he will likely be allowed to do so. But if he is not willing, or once the purposes have been fulfilled, example, the pets have died, the resulting trust arises in favor of the transferor or his or her successors. Also remember that in the absence of a statute, many jurisdictions will void an honorary trust on the basis of the rule against perpetuities if its duration may be more than human life in being plus 21 years. Next, Section B, who may be a beneficiary? Broadly, any person, natural or artificial, who is capable of taking or holding title to property may be a beneficiary of a private trust. Number one under that section, minors and incompetents. Thus, minors and incompetents may be and often are beneficiaries because they have the capacity to hold title. And two, unincorporated associations. At common law, a trust in favor of a partnership or unincorporated group will fail unless the gift was construed as a class gift to the partnership or group's members. And under A of that section, entity theory, the trend today is to treat unincorporated associations as legal entities for the purpose, for at least some purposes. Example, to sue and be sued in a group name or to hold title to property. Accordingly, they now generally can be trust beneficiaries. Page 48, Section B, non-charitable associations. Nevertheless, a trust for the continuing benefit of a non-charitable association may present special problems under the rule against perpetuities because it has neither the immunity of a whole charitable trust nor is it tied in duration to the period measured in human relation to human lives and being. Next section, C, who is a beneficiary? The problem of incidental benefits. Not every party who stands to benefit through operation of a trust is regarded as a beneficiary of it. If the trust only incidentally benefits an individual or entity, that natural or legal person is not a beneficiary and cannot enforce rights thereunder. So the big thing is that you have to have the rights to enforcement, and you have to be a beneficiary that's not an animal or something. So example here, if the trustee is directed to invest a portion of the trust estate in bonds of a particular corporation, the corporation is not a beneficiary and cannot sue to compel the trustee to follow the directions. And that's Scott's on trust at Section 126. The beneficiaries can, however, surcharge the trustee for damages of any result from the breach of duty in failing to follow valid trust terms. Another example, if the trust provides that the trustee is to employ X to perform services for the trust, authorities presume, absent any contrary evidence, that the provision is for the best interest of the beneficiaries and not to provide the benefit of employment to X, whose benefit is merely incidental. Under this interpretation, X would have no right to enforce the provisions directing her appointment. Only the beneficiaries would have cause to complain if the trustee fails to follow the settler's instructions and they were damaged as a result. So we got to be beneficiaries when we want to make a claim. Next example, suppose the conveyance is debtor to friend in trust to pay creditors of debtor. If this is construed as a trust, some cases hold it is mere agency though, it should be considered a trust for the benefit of debtor, the debtor's transferor. In other words, so with the power in friend to pay debtor's creditors. The creditors are not beneficiaries and have no right to enforce payment unless the trust grew out of the creditor's composition of compromise agreement, perhaps a third-party beneficiary if the dealings were contractual in nature, see the contract's summary. So otherwise, the trust would be terminable at will by the debtor as sole beneficiary and settler. So here's an exam tip here. It is important to remember that not everyone who benefits from a trust is considered to be a beneficiary. The trust must operate directly to benefit the person. Individuals and entities, incidentally, or indirectly benefited, cannot enforce trust provisions. Next section, D, requirement that beneficiaries be identified or members of a reasonably definite class. A valid private trust requires beneficiaries capable of enforcing it, and those beneficiaries must be ascertained or ascertainable when the trust is created, or certainly become ascertainable, if at all, within the period of the rule against perpetuities. The purpose of this requirement of identifiable beneficiaries is, ostensibly at least, to assure that the trust is or will be enforceable, which in turn ostensibly requires or will require persons who are identifiable as beneficiaries or members of a reasonably definite and ascertainable class of beneficiaries. One under the section there, beneficiaries unascertainable when trusts created. A beneficiary need not be identified or even identifiable at the date the trust is created. It is sufficient if the instrument gives a formula or a description by which the beneficiary can be identified at the time when the enjoyment of the interest is to begin. At that time, however, must be within the period of applicable rules against perpetuities. That is, under the traditional common law rule, it must be certain at the outset that the beneficiary will either be ascertainable so that his interest will vest within the period, or that interest will fail by that time. In either event, there will be absurdly be ascertainable beneficiary and an ability to enforce the trustee's duties either via the expressed interest or by way of a resulting trust. An example of that is the settler's transfer to trustee and trust for sister for life, remainder to sister's children, is clearly valid. This is true even if sister had no children at the date the trust was executed. Whatever children sister later has will necessarily be ascertainable by the time enjoyment of the interest is to begin, in other words, on the sister's death, If there are no children, there will be a resulting trust for the settlor or his successors in interest. So next section, note. The same should also be true for 1, a trust executed for the settler's wife at that time when the settler was still unmarried, and 2, the trust solely for afterborn children of the settler, or even number 3, a trust for a corporation to be formed, an example, by the settler or within 21 years. B, the status until beneficiaries ascertained. If the as yet unascertainable or unascertained beneficiary or beneficiaries are the sole beneficiary or beneficiaries, example, S to T in trust for children of B when B has no children. 1, the minority view here, the trust is invalid. A few decisions have held such a trust to be invalid, but this result is highly questionable and may be explained by the fact that the case involved taxation at the time when tax doctrine itself seemed ill-equipped to deal appropriately with the situation presented by the trust if it were recognized. And the majority view here, the resulting trust, a more sound and usable view is that the trust is valid and enforceable, and that until the beneficiaries are ascertained, the trustee holds tentatively on a resulting trust for the benefit of the settler or for the settler's heirs or other successors in interest. So this resulting trust is subject to an executory limitation on which displaces the equitable reversionary interest, that is, the resulting trust, and places equitable title in the intended beneficiary or beneficiaries if and when they come into existence, unless the settler has reserved a power of revocation, and express trust cannot properly be defeated by a subsequent agreement between the settler and the trustee. To attempt to do so would be a breach of trust. I want to read that again. Unless the settler has reserved a power of revocation, the express trust cannot properly be defeated by a subsequent agreement between the settler and the trustee. To attempt to do so would be a breach of trust. Next, section C, purported trust remainder to heirs of settler for life beneficiary. 1, the doctrine of worthier title. Suppose settler deeds to trustee and trust for brother for life, remainder to the heirs. In most modern jurisdictions, the settler's heirs are remainder beneficiaries, individually unidentifiable with an enforceable interest nevertheless, so long as the settler lives. The doctrine of worthier title invalidated the remainder that was limited to grantor's heirs. Therefore, any jurisdiction that may still follow the doctrine of worthier title, there is, or presumably is, no remainder in the heirs, but instead there is, or presumptively there is, a reversion in the settler himself. So when the doctrine has been treated as the rule of construction, that is a presumption, and here we come with the construment, so it has generally been applied to personality as well as land as the rule of law, that is a prohibition, and it applies only to real estate. Number 2, rule in Shelley's case. Suppose settler deeds or devises black share to trustee in trust for brother for life, or remainder to the heir of brothers. Today there is a remainder interest in brothers' heirs, unidentifiable beneficiaries of the nonetheless enforceable interest in a definable class so long as the brother lives. So under the rule in Shelley's case, now apparently extinct, the remainder limited to the life's estate holder's heirs was not recognized. And under some circumstances in those jurisdictions that follow the rule, brother, not the brother's heirs, would have the remainder, and thus brother would have had complete equitable title, merging into full title in fee simple. So 2, caution, formal requirements must be satisfied for identification of beneficiaries of testamentary trust. In the case of a trust created by the settler's will, the beneficiaries must be identified in the will or in a codicil or by other admissible evidence, and says we're going to get to that below here. And the will or codicil must be valid under the statute of wills. That is, the will must, among other things, be executed in accordance with the applicable Wills Act. Next section, A, reference to extrinsic writing. Where a will does not identify the beneficiaries but involves reference to another document, that document must either satisfy the requirement of the applicable Wills Act or must satisfy the requirements of the doctrine of incorporation by reference. So the doctrine which allows extrinsic documents not present at the time the will was executed to be incorporated into the will may be relied upon to complete the terms of the will. Now, we could use that to our benefit, really, because all I have to do is incorporate it in by reference. So if you did an accept for value on the face of a document, and on that acceptance there you said see another document, which would be, say, example of this codicil, then this is going to be incorporated in here by reference. Next section, reference to acts of independent significance. Where unnamed beneficiaries of testamentary trust are to be ascertained by a formula or description, that identification must be based on acts of independent significance. Under this doctrine, a will may be disposed of property by reference to acts or events that have significance apart from their effect on disposition made by the will. An example here is a bequeath to Henry Oxford in trust for such person as he believes most deserving for having cared for me in my last illness is enforceable. The beneficiary is ascertainable from circumstances outside the will that have an independent significance. In cases of doubt, the court can receive extrinsic evidence to determine the person's identity or entitled to take. Page 53, class of gifts. A private trust may, and usually does, at least in part, benefit members of a class of persons. The persons are trust beneficiaries and their interests are valid provided the designated class is described with sufficient certainty that its membership is or will become reasonably definite and ascertainable within the period of the rule against perpetuities. A, some special class gift or question. 1. Was the class gift intended? Assume the settlers conveys to trustee and trust for the directors of the XYZ Fraternal Society. Is this gift to the directors as a class or is intended as a gift to an association? Class of this type are generally resolved by extrinsic evidence of the settler's probable intent. So if the gift is construed as one of an association, this must raise the problem of whether an unincorporated group can be the beneficiary of a trust. So it wasn't properly expressed in the beginning, which allowed room for them to construe it because it wasn't specifically spelled out, and now you've opened the door for the court to construe whatever comes down the pike. So 2, when this class determined, assuming the class gift was intended, did the settler intend to benefit the present and or future members of the class? This is merely a problem in construction of the trust instrument and is frequently encountered in gifts for a person's family. So the exam tip here, if it appears that the settler intended to benefit future class members, the identity of the future beneficiaries must be ascertainable within the period of the rule against perpetuities for the trust class gift to be valid. Next section, B, effect of trustee or other persons having power to select among class membership. Trust interests for members of class are normally uncomplicated where a class membership is limited and definite and where the class members receive the property of benefits in equal share or in other fixed portions. Frequently, however, the trustee is given the power, perhaps couched in the terms of discretion, to select or to allocate a portion trust benefits among one or more members of a designated class. Trusts based on such powers are clearly valid if the class is sufficiently definite. But if the class is not sufficiently definite, the trustee's power of selection will normally not make the class definite or render the potential beneficiary sufficiently ascertainable to sustain the trust in American jurisdictions. Next section, 1, the amount of gift need not be certain. So the fact that the amount distributable to each member of the class is uncertain Example, merely because the distributions are subject to a trustee's discretion, even uncontrolled discretion, does not impair the validity of the gift. As long as the class itself is sufficiently definite, the trust will be upheld. And A, the trustee's discretion. If the trustee of a third person is given the discretionary power to distribute among a class, the usual interpretation is that the trustee has the power to do so selectively. That is, can give all to one or more of a class and exclude everyone else. So this is nevertheless the possibility that a particular exercise will be found to be an abuse of discretion here. Under B now, the successor trustee appointed if trustee fails to act. On the other hand, if the trustee fails or refuses to exercise his discretion as to which members of the class shall take, the court may appoint a successor trustee who may exercise the power provided the courts that the settlor would so intend, that is, that the power is not personal to the original trustee and that the trustee's non-exercise is improper, not what the settlor had intended to permit, in other words, or the court may, if deemed necessary, direct distribution as a matter of construction, having all members in the class share equally, or perhaps according to some other principle such as the representations or per stripes, if the class, stirpes, if the class is somewhat issues or descendants, and see Scott's on trust at section 120, if you want further on that one. Okay, now we're going to stop right there. We'll pick up there next time. That's on page 54. We'll start at number 2, power of trustee to appoint to himself. So now, if anybody has their UCC, maybe they might want to quickly open it or go to UCC. I might want to mention, a lot of this may sound like a bunch of gobbledygook, but as we opened up with, we all have the fact to have and to hold, the capacity to have and to hold the property. But do we have the capacity to administer the trust? And the capacity to administer the trust is going to come through knowledge and understanding on how to operate a trust. And that comes in with the terminology and knowing the examples and the restatements of maybe the first, seconds, and thirds and other trust material. Because if you ever get into a trust where you have some assets, you don't want to be incompetent and have it all taken away from you because you are incompetent. Because if you make a mistake and you do something wrong, you're going to be stripped of the trust. So it's imperative that we study, that we have knowledge and we know and we understand these things, be competent so that we can administer the trust as well as to hold the property. So now I really want to go to UCC 9-336. 9-336 in UCC. I've been reading UCC for a long time, and I've been basically looking at UCC through debtor-creditor eyes and trying to achieve creditor standing by making a bigger lien against somebody, and I'm firmly committed to the belief now that the only thing we're doing by doing that is we're creating a bigger debtor. I don't think you can have standing by coming through UCC directly. You can't get a remedy. Your remedy is not in debtor-creditor relationship as a secured party creditor. Your remedy is in trust. And if you choose to have anything, then you come through the trust and you interface back into debtor-creditor again through the trust. And then you have secured party standing once you have the trust. So it's not who you are as creditor, it's who you are as grantor first. And if you want to choose to operate as trust creditor in commerce, which you're probably going to have to do, but you can't get there directly by going through UCC, say. You have to get there through trust first. So I've been looking through UCC like everybody else under UCC eyes, debtor-creditor eyes, and now I'm starting to see things a whole lot differently looking through trust eyes. And now 9-336. 9-336 is talking about commingled goods. Now, there's two ways of looking at this, like I specified. You can look at this as being under debtor-creditor. So let's look at that first. Let's look at this 9-336 as debtor-creditor eyes, and we're talking about commingled goods under A. Commingled goods means goods that are physically united with other goods in such a manner that their identity is lost in a particular product or a mass. B. No security interest in comminglable goods as such. Now they got that. That's the heading of it. So a security interest does not exist in commingled goods. A security interest does not exist in commingled goods. So let's think of this as being the goods being your note, and they securitized your note, which is like they've homogenized it and put it in a pool, and they mixed it up with everything else in that pool, and everything in that pool all looks the same, and nobody can tell one thing from the other in that pool. That's commingled goods. So this commingled goods, if it had a security interest in it, does not exist in commingled goods. Now, under the official comments, number 2, it says commingled goods. Again, it gives you the definition of goods whose identity is lost by commingling with other goods from which they cannot be distinguished. And it gives an example of ball bearings. So number 3, the consequences of becoming commingled goods. By definition, the identity of the original collateral cannot be determined once the original collateral becomes commingled. Consequently, the security interest in the specific original collateral alone is lost once the collateral becomes commingled goods, and no security interest in the original collateral can be created thereafter except as a part of the resulting product or mass. Next paragraph. Once collateral becomes commingled goods, the secured party's security interest is transferred from the original collateral, the house, to the product mass, the pool, the securitization pool. So see subsection C. If the security interest in the original collateral was perfected, the security interest in the product or mass is perfected security interest. See subsection D. This perfection continues until lapse. Now, I haven't gone any farther as reading the other comments in there, but I'm going to do a little further study on that, but this looks very promising. This is a bingo. If you just want to look at this as debtor-creditor eyes, once they've commingled goods in securitization, they've lost the security interest, and the security interest transferred from your property to the pool. And why are they coming back at you and doing a foreclosure? And this ties in with the landmark case on September 21st of 2009, where in that case it's Landmark National Bank versus Kessler, 2008 or 2009, Kansas, and there's other cases that back that up, where it talks about on the article that I have here, the real parties and interests concealed behind mirrors have been made so faceless, however, that there is no party withstanding to foreclose. The Kansas Supreme Court stated that Mears' relationship, quote, is more akin to that of a straw man than to a party possessing all rights given a buyer, the court opinioned. So next quote, by statute, assignment of the mortgage carries with it the assignment of the debt, and indeed in the event that a mortgage loan somehow separates interest of the note and the deed of trust, with the deed of trust lying with some independent entity, the mortgage may become unenforceable. The practical effect of splitting the deed of trust from the promissory note is to make it impossible for the holder of the note to foreclose unless the holder of the deed of trust is the agent of the holder of the note. Without the agency relationship, the person holding onto the note lacks the power to foreclose in the event of default. The person holding only the deed of trust will, however, experience default because only the holder of the note is entitled to payment of the underlying obligation. The mortgage loan becomes ineffectual when the note holder did not also hold the deed of trust, unquote. So mirrors as straw man lacks standing to foreclose, but so does the original lender, although it was a signatory to the deal. The lender lacks standing because title had to pass to the secured parties for the arrangement to legally qualify as a security. The lender has been paid in full and has no further legal interest in the claim. Only the securities holder has skin in the game, but they have no standing to foreclose because they were not signatories to the original agreement. They cannot satisfy the basic requirement of contract law that the plaintiff suing on a written contract must produce a signed contract providing he is entitled to relief. Now tie that in with what we talked about under 9-336 under debtor-creditor I's. That when it said that the secured party's interest on the security interest is transferred from the original collateral to the product or mass. In other words, it's been separated. The note from the deed of trust has been separated, just like the case said. So the security interest in the specific original collateral alone is lost once the collateral becomes commingled goods, and no security interest in the original collateral can be created thereafter except as part of a resulting product or mass. So now, let's look at this under trust eyes. Let's go to the Bank Officer's Handbook of Commercial Banking Law, the 6th edition by Milton R. Schroeder. I'm going to go to, I think it's 19, section 19. 19.02 under C talks about special deposits. Special deposits may take on a number of forms. Sometimes they are a means of holding funds in litigation, trust funds, and cash securities of various types, and such as deposits to show good faith in the case of contracts and the like. Attorneys maintain such accounts to hold funds of clients for whom they are fiduciaries. Special deposits are created by special contract between the bank and the depositor. In most instances of special deposits for the benefit of a third person, the bank becomes a trustee of the deposit of the benefit of the named person. Special deposits are often payable upon demand, sometimes upon terms, and occasionally they bear amounts of interest. And in many instances, such accounts are evidenced by certificates of deposit. So now we want to go to Black's Law. I want to go to Black's Law. I'm going in the revised 4th edition. I want to look up trust deposit. So, trust deposit. Where money or property is deposited to be kept intact and not commingled. So here we go. Not commingled, like 9-336 says. No, not commingled. We're talking about commingling there. So where money or property is deposited to be kept intact and not commingled with other funds or property of bank and is to be returned in kind to the depositor or devoted to a particular purpose or requirement of depositor or payment of particular debts or obligations of depositor, also called special deposit. So a special deposit is also a trust deposit. Can't be commingled. Now, let's go to 9-336 again. So if I'm doing a trust deposit, a special deposit, when I put it into the bank, say, I should get the same thing I put in back out. So if I put a note in special deposit, I get the same thing I put in back out, no alterations. Otherwise, if it's been altered in any form, it's been commingled. And commingling would be conversion. It would be a breach of trust, breach of fiduciary duty, and those would be your causes of action you'd use to do an enforcement as a beneficiary. So once they commingle the funds, they not only on debtor, creditor law lost the security interest to foreclose, you got them between a rock and a hard spot under debtor creditor, but now you got them under commingling of funds. If you can prove the commingling, because number one, if they didn't give you the deposit back, they converted the funds, and they probably never will give you the note back because they can't, because that would be the proof they commingled it. And they're not going to do that. So you got them under trust, you got them under debtor creditor. Whichever way you want to go or whichever you want to play it, they're in a double rock and a hard spot, except you never knew or understood what was going on, and therefore you had no rights, just like Jefferson says, he who sleeps on his rights has no rights. So that's why it's important to study and know who you are, but not knowing who you are as creditor, knowing who you are as grantor first. So I think that's some powerful stuff there. So let's open it up for some questions, or anybody have any comments or whatever.
Be sure to hit *8 on your phone if you have any questions, and I'll see it pop up here, and I'll go ahead and unmute you. Still looking here, see if anyone's got a question. Hit *8 on your phone, folks.
Did I bore everybody to sleep?
Oh, here we go. A couple showed up. First one is D. Michaels. You've been unmuted. Go ahead with your question.
Hey, Christian. How you doing? This is Darren.
Oh, Darren, how you doing? All right.
Good. Few questions that I was thinking about, because normally I relate to what you're saying to like most insurance contracts that you have out there, like life insurance or annuities, where you have like an insured or an annuitant, and then you have an owner, which they can be either party, and then you have, of course, the beneficiary designation. And, of course, the beneficiary does not have to be notified that they are, in fact, a beneficiary, because they have no rights until that contract has dissipated and has been canceled. In other words, proceeds have been dispersed at that time. I guess my question is now how the courts are doing this is typically is when a person does recruit and retain a legal representative, because the courts can only recognize another legal fiction where they can only recognize, of course, corporation trust, or also a ward of the court pursuant to Corpus Juris Secundum, Volume 7, Section 4. So that's where you're really deemed incompetent to manage that trust. Would you agree?
Yeah, the fact that we don't have the knowledge or the understanding what's really going on, yeah. We're
so
being
okay, so that's kind of like where they lure you in there, but
that's what's so powerful about the trust. But that's how they've been using it against you. But then now, if we flip that, we use it against them, because now we understand how they're using it.
Correct.
I mean, all these courts are trust courts, but they're construing it that you're coming in under debtor creditor, when they know darn well it's all about a trust.
Right, because I was reading some of the, but this pertains to trustee. Like, you can decline a trusteeship under Florida Statute 736.0701, and then it also shows which is and the right of trustee to resign that trusteeship is also under 336.0705. Now, typically, that's where if you can come in, and I'm assuming you could do this with almost any court action, is where you're coming in with an affidavit or a declaration to change that trustee position. Now, the question is, if you say you're coming in as grantor. You're saying, no, I'm not the trustee. You were assuming that position, but I'm telling you I'm the grantor of and the beneficiary of this Sestacue Trust that, of course, they name in the all-cap letter. Now, the thing, point new trustees, which let's say can be the opposing attorney or the judge or whoever you want, is there anything that they cannot accept it, or do they have to issue an order by not accepting it, or will they declare it a legal nullity or something along that terms? You know where I'm going with that?
Yeah, well, we're looking under Title 26 IRSC code there, under 7701. And
right.
All U.S. employees have a fiduciary duty. So if you can prove that somebody's a U.S. employee or a U.S. person, now they have fiduciary duty, and they can't refuse.
Well, typically, especially if it's a judge, typically they always sign in because they do have to take
off. So that might be a little bit different. Well, we've been checking that out a little bit more for that. Anybody who's in office might not be, say, liable for can't get out of a trustee appointment. He may have the right to refuse, but still, even if he does refuse, what happens is that the court is going to form a resulting trust. The property is going to revert back to the grantor, and he's going to become temporarily like trustee, holding the property until the court appoints a successor trustee. Because now it's up to the court to appoint a trustee. Because the equity is going to say that the trust cannot fail for a lack of a trustee. So the court cannot let it fail. So the court's going to appoint a successor trustee. But then once he notifies me who the successor trustee is, so I know where to send the trust property to, now the trust can be completed.
Okay. Yeah, but you can actually prove most of them under 267701 because most of them do loyalty oath as a public in a public position, government position at any level, and also too if they're a registered voter. Because question number 2 in the voters' registration says, "Are you a U.S. citizen?" We'll put them into that category. And typically, if they are of any type of judgeship of a partisan where they have to be elected, that's one of the prerequisites as well too. So they're pretty much hung on that avenue.
Yeah, well, it comes down to whatever you can enforce, but you got several options, ways you can go there.
Well, let me ask you one particular question because I'm stuck on this one case, and I've been fighting this for years, but I know what they've been doing, and it's amazing because I've had 4 judges removed from it, 4 magistrates, and 4 attorneys from the State Attorney General's office, and now this chief judge basically will not let me file anything into the case. He's saying it's done, it's over, and I'm going, no, it's not. Recused and you're still adjudicating orders, so that's a violation of your canons. But my question is, because when I named him and all the other officers involved as trustees of this, that's when, and it got filed into the docket, he had it removed. Once it got filed, he had it removed, which of course is tampering with evidence. But what can I do to actually do the same thing? Do the a notice of newly appointed trustees? Where else can I go with it? Except because I can't take it into that case, they're going to kick it right back. That's what they do.
Well, I would say the fact that they stole the evidence or tampered with the evidence in the file there, then you come out and bring charges, for theft because somebody in there is, stole my documents.
Right. Well, they mailed them back to me is what they did, but that's even on the docket too as well.
Okay, so, the next thing I'd say, if they can't let you file documents, what I'd do is I'd come back in with independent action and sue the case. That's going to be down the road. It's going to be a very big case. I had a federal judge look at this case, and he told me, he goes, do you know why they want you so bad in that county? He says, you could bankrupt that county with this case. I mean, it's that big. The next time I've come in, I've come under trust position. Correct. Well, that's what I did when I went to remove. What I did is that I basically stipulated saying, no, I'm not the trustee. I'm the grantor or the beneficiary. But I am basically decreeing new orders to the. Did you not put that on a counter in that case? I'm sorry. Say again. Did you use that trust position as a counterclaim in that case?
Basically, I came in and I just noticed the court. I said, basically, I corrected the assumption, and then I named all the officers of court that, hey, you are now appointed the trustee, and also sent notification to the Internal Revenue Service.
I think sometimes what we need to do is we need to provide a way out for our brothers to bow out gracefully. So we need to have some kind of colorable claim on the public side of the case that allows them some way to say, yeah, you're right. We're gonna close this case down based on that. Because I think if you put them between a rock and a hard spot, they got no choice but to fight. But if you give them a colorful way out, I think they'll take the bow out gracefully because they know you beat them.
Well, I agree with that to a point, but just like on another case I'm working with a retired judge in Florida, he just says that the fraud is so blatant in the judiciary, and this was a retired Florida judge that's had over 8,000 cases in Florida that he's working on with me on one case.
One-on-one battle here, You might have to move it another case or something, and then But my point is, back on the other one, if you came at him with a counterclaim, how did you file the counterclaim?
Well, I haven't filed it yet. It's going to be a big one in a minute.
Came in under trust. Did you file the filing fee and serve it?
I have not. I have not created a countersuit yet. I will. It'll be a big case. It'll be something that will take a while to develop. But right now, and you saw the paperwork on it before, because that case was posted with a $10 million private indemnity bond, and they accepted it. They've held it, but they have not closed the case. I even filed abatements and everything else, and they still they haven't done anything. They won't do anything. They can't enforce it either.
The bonds.
I'm sorry?
What did you do with the bonds?
Well, the original went to the clerk of court.
Did you foreclose the bonds? They have no upward pressure coming down on them to close it. Do you have an IRS enforcement or any kind of is anybody liquidating the bonds? Does Treasury have the bonds they're going to liquidate, and they're coming at them for those?
Right, and that's another point that I'm going to have to do. I'll have to go under 3949A form, come in as whistleblower to have them enforce it to close that case, because technically they are defrauding the federal government.
Yeah, because I want my big brother, the IRS, on that, because he's my friend. He's the one that's got the muscles to close the case down.
Yes, and they get any judge or any officer of court, you bring the IRS in, it gets their attention. And if you could use them,
or you as person,
and if you could use them, if there's a way that you can basically realize that, hey, that maybe this agency here that's actually operating as a private corporation is a government, and you could really get their attention by documented evidence, you may be able to win some friends on that side of it.
Right. Yeah.
See what happens. Okay, very good. I appreciate that.
All right,
okay,
our next one's Blackwater Frog. Go ahead, you've been unmuted.
Hey, guys. Thanks for being on, Christian. I always enjoy these, although I've missed several lately. First off, I wanted to ask, where's the best place for me to go to get the basic elementary knowledge of trust? Because I'm a lot of the things you're discussing here are a little bit beyond me, so I need to back up and get that elementary stuff. Where's the best place to get that?
Gilbert Law Summaries.
Gilbert Law Summaries. Okay.
Yes. It's entitled Trust.
If you go to Amazon.com and type in Gilbert Summaries Trusts, it'll come up. It's like $28 with free shipping.
Gilbert Law Summaries on trusts.
Yep, 13th edition.
2000 version is what I got. So.
Say again, Chris?
The 2008 version is what I've got that I'm reading from.
2008 version?
Yeah, copyright 2008 one I have.
Yep, that's what I have too, Christian. It says it's the 13th edition.
Oh, okay, great. Cool, guys. All right, I'll look for that. And I didn't have a specific question.
I went to Google search for Carlton Wise Trust Handbook. That's also free. That'll give you a good trust primer.
Carlton Weiss. Oh, yeah, actually, I have that one. I should read it again because my first reading, I don't think I absorbed much of that. So I think as I'm gaining a better understanding from listening to these calls and both live and pre-recorded, I think it'll make a lot more sense for me to go back. Carlton Weiss. Yeah, I actually have that. So I didn't have a specific question, but I was going to see if you might explain to those of us like myself who are not quite as far along, how would you explain a collections litigation situation in trust terms? In other words, what's going on there in trust terms? And that's really all I was going to ask.
Okay, what I would do is 3 steps. Number 1, express and prove the trust.
No, I'm not asking for really what to do in that situation. I'm asking if you'd explain what's going on. In other words, they're like, for example, it seems to me that they're construing the defendant to be the trustee and that sort of stuff. What's the mechanics?
Right, you just go to Black's Law 8th edition and look up trust, and you read everything that's under trust. You will probably answer that question yourself.
Okay. All right. Very good. Thanks.
Especially look up implied trust under that trust heading and constructive trust and implied trust. Expressed and implied trust. There's only 2 classifications of trust, expressed or implied. And when you get down to the one section that talks about, let me pull it up here.
Well, okay, so that opens up a question then. So, let's just follow that an example. In a collections litigation scenario, what's being construed? Is an implied trust being construed?
Yes. If you look up under trust, under Black's Law, and under the headings under trust, you're going to come up to constructive trust. It says constructive trust, an equitable remedy that a court imposes against one who has obtained property by wrongdoing. You're really construed to be the wrongdoer. So a constructive trust imposed to prevent unjust enrichment creates no fiduciary relationship. Despite its name, it is not a trust at all. And it says compare resulting trust, also termed implied trust, or an involuntary trust. And then down below that, the next paragraph, it's quoting from a case here. It says a constructive trust is the formula, or your remedy really, through which the conscience of equity finds expression when property has been acquired in such a circumstance that the holder of the legal title may not in good conscience retain the beneficial interest. Here it comes. Equity converts him into a trustee. So it is sometimes said that when there's sufficient grounds for imposing a constructive trust, the court construes the trust. The expression is, of course, absurd. The word constructive is derived from the verb construe, not from the verb construct. The court construes the circumstances in the sense that it explains or interprets them. It does not construct them. So what it boils down to is when you fail to come in and express the trust, they're going to construe the trust, and they're going to construe you to be the trustee, and you have breached because you didn't make a payment. And you are assumed to be guilty, and you cannot hardly prove yourself innocent unless you paid.
So in that scenario where you have a third-party debt collector bringing action against a supposed creditor, / defendant, how is it that they've created? How is it that the trust situation is created from the start? Is it just the fact that they've brought an action? Is that in itself being construed as that a trust exists? I mean, what is it that allows?
Everything is operating on a trust. Yeah, subtrust, subtrust, and subtrust. Everything is based on really a trust, and they're getting you to voluntarily form a trust for them by your signature.
So if you never gave a signature to the third party, in other words, the third party debt collector is making a claim that they have some right to some other agreement that the defendant may or may not have had with some other company. They're really not a holder in due course of any note. but yet they're coming into court with an action. Somehow that action.
You're thinking under debtor creditor. You got to think under trust, and under trust, no party in the trust need to know or understand they are forming a trust. Bingo.
Okay. So if I never signed anything with the third-party collector, how did the trust get created?
If I give you my pen and tell you I want my pen back, you're going to use it. No, I want my pen back in 2 weeks. We just formed a trust.
Oh, so just based on the fact that they sent a letter saying you owe us money means a trust was created.
Yeah. No party in the need to know or understand that a trust is being formed as long as the necessary elements are there: intent, purpose, parties, and specific trust res. And one of the 4 methods of formation, and those 4 are by declaration, transfer, appointment, or contract. Now we have a trust that the law will recognize, and you've been trusted.
So in a collection litigation scenario, which of those 4 methods were employed to have created a trust?
Well, one of them is transfer, and transfer is by delivery. Next one is one of them is endorsement. Did you sign something? Another one's assignment. Another one's by operational law.
So, I guess what I'm getting at is that I never signed anything that had anything to do with the collection company.
You don't have to. It's your conduct. Declaration can be by words or conduct. It can be written or oral. Conduct can be silence. So in other words, if you didn't respond when you should have responded, a trust was formed. You never knew it.
Right, but if you did respond and you ended up in court, so that something you said in court may have created the trust scenario, the trust arrangement.
You're the debtor that didn't make the payment, and you're guilty because that's the next thing of the power of the trust. Because the trustee, upon the beneficiary making a complaint that he didn't pay, is presumed already guilty. And the only way he can prove himself innocent is if he got a record of a payment. Do you have a record of a payment?
So, in that scenario, I'm sorry. Go ahead.
The burden of proof shifts immediately once the beneficiary makes a prima facie case, and the burden of proof shifts to the trustee to prove, and he can't prove unless he's got a record of the payment because it's his duty to make a payment, disperse the funds.
So in that scenario, of course, the defendant is being construed as the trustee. What the plaintiff is construed as the beneficiary at that point.
Right.
And until you come in and express it differently than the way they've construed it, then it stands as it is.
You're the only one who can correct the error, the misconstruement.
Okay. I'll stop there and let someone else ask a question. If there's someone in line, I don't know.
Yeah, we got one more here.
Thank you, gentlemen.
Come back in later.
Okay.
Hey, Christian, this is Eric here in Florida again. Good to talk to you. And I want to thank the last caller for bringing that up and getting that broken down because that really helped, I think, a lot of us understand things. The first thing I want to figure out that I've been looking at is the SS5, and we obviously, based on what you were talking about in some of your previous conferences, we signed that as grantor. But under number 3, citizenship category, what do we want to put there? Do we want to mark one of the boxes that are there because it doesn't seem appropriate, or do we want to make our own box and put something else?
Well, I have put American on the other block up there, but there's no place to put it in there, but I wrote it in there anyway. But now I'm thinking, that's just a debtor form anyway, so they want to see the debtor on there. The debtor is really the straw man. And the straw man is really a United States citizen. But I'm going to sign, say, as grantor on a different kind of capacity or by authorized representative, and I'm just, the debtor, the straw man, is not me. I'm the grantor. A different, total entity, different.
Good point.
And that is a starting point that we utilize to express the trust because if I remember right in some of the things you've talked about before, we express it on the SS5 and then file that make 2 public record filings because then it stands as a fact. Is that what you've talked about in the past?
Right. I'm just using that form to create a record that under 3-105 of UCC, really, that, and according to that case I discussed before, that bankruptcy case, it said that the maker of the note is the trustor or the grantor. And the beneficiary on the note is the payee. And it was talking about a mortgage case. But anyway, that proves the fact that the signer of the note or the signer of the instrument is really the grantor of the whole thing. And that's the proof that I need to prove up the fact with the SOI of my claim on my NOI.
And the SS5, we would want to file that before a case. Like, for example, I don't have a case pending against me in a mortgage, as you mentioned, but can you do a public notice filing? And then that would obviously be in our local public notice depository with our courthouse. And then would we also make the other public notice filing through the Secretary of State, or would there be another place we would want to notice that in the public?
Well, I've been using the UCC1 Secretary of State as one public notice and the county as the second public notice, so that I have two records or two public witnesses. And these are just notices. These are not the actual documents filed in the public.
Okay, and then are you aware of any office within a lender that we would want to notify to express the trust, so we can go ahead and claim our note, so we can bring it back, so there's we can force them under into a situation where they've either breached and they got to go ahead and credit our account, or we can express and then they can act accordingly for under the rules of trust.
Well, they've already credited the account on the asset side because that's where your note's been ledgered into, but then the UCC and the security agreement is ledgered on the liability side, but you never told them to balance the account. So I guess that by expressing the trust, so that you have the authority, that you establish yourself as grantor position or beneficiary, and then you've got the ability to make a claim as beneficiary to order them to compel them to do the duty as trustee. But now the bank might not be the trustee at that point because, they appointed a different trustee by your power of attorney on the mortgage application that you made, and that's the title company. So the bank is really just the beneficiary. Although they're holding both sides of the note, really, and they should still be holding, according to trust, holding it in special deposit or trust deposit, unless they commingle the funds and set it onto a securitization, which we know that's what they did. So now you got them between a rock and a hard spot. I don't care which way you go, either trust position or debtor creditor under UCC under that 9-336. You got them either way.
So is there a special office that we can locate within the lenders that we're dealing with? For example, mine's Chase, that might address this issue, or is it you just send it into the normal department that you would send your mortgage payment into?
No, I'm going to send everything to the CFO because he's the guy, the bookkeeper. And him and the CEO are the two that know everything of what's going on in that bank, or at least they better, and they're the liable parties. So do a search to find out who your CFO is and address it to that man and title CFO.
I sent some documents out to the president of the company recently, and we could just put notice to the agent as notice to the principal, and that's sufficient, right?
Yeah, but I would notify both of those entities, CFO and CEO.
Okay.
Make sure you got a specific name.
Yeah, I did address to a specific name when I sent it out to the president, but I didn't address to the CFO. But we'll see what happens in about another 10 days to see if there's any response at all, based on the fact that it did a notary presentment. Now to switch to
prove the trust first.
Repeat that, please.
You have to claim the trust and prove the trust first.
And of course, that's through the SS5 and doing a public notice filing of it.
Well, in this particular case, on a mortgage, if you're talking about a mortgage case, no, I don't really have to use the SS5 because the document signature, as I said earlier, the note on the signature on the note is the proof that you're the grantor of the whole thing. 3-105. 3-105 says the maker of the note is the first issuer, and the drawer on a draft. Those parties who sign those instruments are the grantor. So your note itself is the proof that you're the grantor of the trust. Now, that's one witness. Now, I need maybe another witness. As long as I can get two witnesses on this, that I got two documents of proof, two records, to establish my grantor trustee or my grantor beneficiary position. Now,
so who might be another witness? The title company, for example?
Say again?
I said, who might be another witness? The title company, for example?
Did you sign anything else?
A mortgage and many other documents.
Yeah, the application.
Yeah.
All those documents with your signature on it are the proof that you're the grantor of the whole trust.
So any additional documents
on a level that you can see and they understand, although I might have these other documents prepared in case I need them in the future, but I'm only going to come in with enough force as I need to establish the facts, on their level. But once I prove the trust, once I've claimed the trust and proved the trust, then I can go in and I can order or compel the trustee to do his duty after I maybe reassign the trust position to the bank, who is also the beneficiary, appointing the bank the trustee. And now once the entities rest in one, both titles of a beneficiary and trustee rest in one entity, the trust terminates. And upon termination, the trustee is supposed to distribute the funds. If he doesn't distribute the funds, he's in breach of fiduciary duty, he's in breach of trust. And if I made a demand for the note back and they didn't give me the note back, then they're in breach of conversion, cause of action under conversion, and damages, cause of action under damages. And we can go from there with a lot of litigation processes. And, whatever the value of the note is, I can get them for 3 times that plus the value of the note, 4 times. And that's not even talking about administrative remedy or commercial remedy. And then if you turn that over to the comptroller and come in with the SEC forms 15 and 25 with some enforcement, and you start putting some upward or downward pressure from some higher entities on the bank, they're going to be willing to cut you a deal. And the deal is, the only thing I'm going to settle for less is I want the house, I want you to zero the mortgage out, and I want the 3 times damages because you guys, you damaged me. We got a tort claim here. You guys ain't walking off of this. You're going to give me a one-on-one. No, you're going to pay.
I like your attitude about that. And
everybody drops the ball when they get the house, they get the case dropped off, and they don't have the, no, you need to carry it the next step because we need to teach these banks a little lesson. And if everybody would bloody their nose, maybe they'd stop taking our stuff.
I concur. Now, to notice them of the trust, would you just do that in a simple document that's considered that would be titled notice?
Well, I would put a notice and demand for the note to get back, but then there's where the re-expression of the trust comes in, and I have, I've been going over 4 lines with some case sites that we're building on those as a takeoff point, where really you're just coming in and saying, I am the grantor and I am the beneficiary, and I have intent and is my purpose that I have filed these documents, and I'm making a declaration basically, so I'm forming a trust by that method. And if I also do a transfer under the UCC 3s, after I prove the trust with the 1s, then the trust has been formed, and now I come in with the instructions, the oral or the written words, which is probably going to be written in this case, with the non-precatory language, make sure we don't have any weak wording in there. I'm going to command and direct or order and tell them basically what I want done, which is, hey, release the funds, do the distribution, or else prove up why you can't. And you got so many days to do it in, or else this may happen, blah, blah, blah.
And if they were to fail, that would be considered breach.
Yeah.
Okay.
Yeah. And have that all done by notary presentment so you can get a certificate, because upon the certificate of the dishonor, you can turn that into the unclean hands doctrine, and if they take you to court to sue you, then you can get an injunction and get rid of the case by them, because equity says that you can't have dirty hands coming into court and ask equity to foreclose or sue on a guy. So equity solely operates under equity, and that's where the private sustaining rights of the man are, and that's where you want to stay. Solely in equity, under trust.
And as powerful and effective as a remedy as that I'm sure will turn out to be, also, could the unclean hands doctrine apply to somebody that you've run an administrative remedy on as well?
Even under debtor creditor, if you get some kind of certificate from a notary estoppel, res judicata, that certificate really is unclean hands doctrine, and you can take that and go a mile with that.
Okay. Now, to change the subject, what about going back to express the trust after, for example, a criminal trial when something's been adjudicated?
After it's been adjudicated.
Yeah.
You can always go back and correct it again because everything's been misconstrued. You might have to come back in and say, sue the case, come back in with an independent action.
And that would be through an SOI, and then to bring it into chambers to do an NOI, and then go ahead and express at that point.
NOI, I noticed that there's a trust, say a claim of a trust, and that's usually going to be in the public, and the SOI is going to be the in chambers, the material facts to support that claim that there was a trust.
And at that point, we'd bring in, for example, the SSI to establish, or SS5 to establish as grantor.
Yeah, if you're going to make the claim of a trust, you've got to prove the trust. If you don't make the claim, I was reading a transcript one time, and the guy's, talking about in the case there, we have a trust here. We got the straw man trust account, blah, 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 and he's talking about all this, and the judge says, I don't see a trust here. Well, if you knew what the judge just said, he just opened up a barn door for you to drive a Mack truck through to come in and prove the trust. But if you don't have the material facts to prove the trust, his last statement's going to stand. There is no trust here.
And at that point, once we bring it into chambers, is that the point to go ahead and introduce, for example, indemnity bonds to go ahead and bond up the case so you can subrogate the judge to act on your behalf? Is that where you would bring in your private
all that private stuff stays on the private side in chambers, because as soon as you put it into court under Federal Rules of Evidence 501, you waive it.
And that's exactly what
evidence rule comports down to every state has got it in there, and in particular, Florida, from where I am, Rule 501 comports down to 90.501 down through 90.510. So there's 10 particular rules, and the ones I want to really pick out is 90.506 and 90.507. 90.506 is privilege with respect to trade secrets. Your rights as a real man are trade secrets. They're CCI information, confidential commercial information. And under 90.507, if you stick this stuff in the public side of the court, it says waiver of privilege by voluntary disclosure. You voluntarily disclose this stuff on the private side, you waive it. I don't want to waive it.
You mean public side, Christian?
Yeah, if you bring it on the public side, you waive it. Read those rules. And this is Rule 501 is going to comport to your local state rules. Look up your local state rules, but find out where 501 changes to your local state. Because in mine, 90.506 and 507 is privilege with respect to trade secrets and waiver of privilege by voluntary disclosure. You read those, and you'll know why you don't want to bring this stuff in open court on the public side.
And at that point, when you went into chambers, for example, people that file bonds in to bond up the judge so they can make their court, when they file it in to the case into the public record, that's where they give it up under those rules, right?
Right. That's what I'm trying to say. Yeah.
Yeah, that's what I thought. That's why people are not finding effective remedy when they're doing this private credit on the end of the public filing.
Yes, part of the problem. Yeah, that's a major problem. Yep.
Okay.
They're putting too much truth in the court, and the court doesn't want to see that stuff.
Okay. And but on the private side, if you go ahead, what?
They got to send you for a psych evaluation.
Right. And so if you were to bring in that private indemnity bond in chambers, the judge at that point you could make the judge aware that you would push your agenda forward because you would have the bigger bond. You would have the greater opportunity to go ahead and close down the case. Is that the idea behind all that?
Trust eyes instead of debtor creditor eyes, and now I'm not just making a regular letter rogatory into chambers. I'm putting in a special deposit,
which further communicates that you're operating under trust instead of debtor creditor.
Right. Mm-hmm.
Okay. And I have a friend of mine who's in prison.
For the indictment is it really going to be the instrument that is the negotiable debt instrument that I turned into the check. It's got my signature on it, prove that I'm the grantor, and I'm putting it back into the court under a special deposit. The whole case is a special deposit back in and itself, which is payment.
Which is the way to bring yourself out of the status of guilt.
Uh-huh.
Okay, and provide remedy. And I don't know if you have anything that you know about this. What would you do to get somebody released from prison?
Well, you got a contract that's bailment that's held against the trust, and you've been construed that they're the owners, and they're not. So you got to go back in and re-express the trust, correct who that status is, as you're the grantor beneficiary, and then you got to get rid of the contract, the bailment contract.
Now, would this apply to somebody who's not an American, not natural-born American? For example, a guy who was born in Germany?
I would think so, yeah, anybody. You're just treated as goods that's being held in bailment in a prison.
Okay. So you would have to dig up that bailment contract wherever that's at.
Well, what you could do is you could claim that it was stolen, and upon theft, as long as you got the proof that everything was done improperly, you can just do an entitlement order under 8-507 of UCC.
I might want to communicate to you privately about this because I have somebody that I'm working on that if you want to participate, it might give you an opportunity to really further your agenda as far as resources if you were to be able to get released.
Mm-hmm.
And what's going on with your workshop? We haven't heard anything, or I haven't heard anything recently about it.
Yeah, we're still working on it. We haven't released it yet officially, so it's.
And for those of us that are sending you emails on it, you're just hanging on to those for when the time comes?
Yeah. Mm-hmm.
Okay. And it's still good email, moving titles of Hushmail?
Yeah, the box gets jammed up, so if it does, send it back again, another time. It should be open, eventually. I keep on getting jammed up with emails. So if you first don't get through, succeed and see till you try and try again.
Okay. Thanks so much, Christian.
Okay, again, my email address is moving titles, one word, movingtitles@hushmail.com. So if you want some information on the release of the workshop coming up, the NTT workshop, send me an email request to put you on the list, so I got you on record. So when we send out the information, you'll get some on that. And again, my email is movingtitles@hushmail.com.
We got a couple more callers here, Christian. I just unmuted Isaiah 555. If you're there, if you can hear us, go ahead with your question.
Yes,
ahead,
this is
Isaiah.
Doug in North Carolina. Kristen, I was looking at Gilbert Law Summaries on page 78. It's item number 3, where it's under Methods of Trust Creation. And it says, number 3, transfer. A trust may also be created by a transfer of property by the owner or owners to another or others as trustees for the benefit of the transferors or third persons or both. And I'm wondering if the money order that I gave to a CFO would be considered res under this transfer.
Yeah. See, I'm trying to get everybody to think of every time you come into a situation, whether it's something coming in your mailbox or you're meeting somebody for the first time, to ask the question in your mind, what type of relationship are we forming here? Because it may be a trust, it may be a fiduciary, an agency, or a debtor-creditor relationship, or other relationships. But my point is, I've got the ability to form this relationship into anything that I want, and I want to form it into a trust. And as long as I got the 4 elements, and I got one of the methods of 4 methods of formation, then I got a trust. And now I'm the big gorilla on the block.
Well, I am entrusting him with this money order. I did have a letter in there that saying I wanted it back if there was anything wrong or any defect in it.
Yeah, so I'm going to turn that money order or that payment into trust res property.
That's what that's the way I'm looking at it, and that's my intent. And on page 81, on point number C, notice to and acceptance by trustee, it says if an effective transfer has been made, a valid trust exists, even if the trustee has not been made aware of it. Neither notice to nor acceptance by the trustee is essential to a formation of the trust. And that situation is exactly what I did in my letter to the CFO. I did not mention or give him notice of a trust being formed, and I'm sure he didn't accept it as a trustee. But that still doesn't...
If you have a valid assignment, there's a trust form whether or not he says, no, I don't want it or not, because really by his conduct, he has accepted.
Exactly. He did not return it in 10 days.
And now, without me looking in there, or at least maybe that section that you read, does it say generally?
This is under the section creation of inter vivos trusts.
Yeah, does it say, starting out, says generally?
No, it says if an effective transfer has been made.
Okay, there's another section, I forget where it is. It says generally the trustee can disavow or disclaim the trust appointment. But it says generally. Now that means there's an exception to that.
Right.
And that exception would be his conduct, even though he may say something different. Because your conduct overrides your words.
Gotcha.
So if I do a valid assignment under UCC 3-say 2, or no, say, what is it? Negotiation and transfer is Section 3, Part 300.
Yeah.
So there's 4 methods that I specified: endorsement, delivery and bearer form, assignment, and operation of law. That's UCC 3-3, 301, 302 in there.
Right.
So even though they may say, okay, I don't accept this appointment. Well, I'm sorry, you passed the time for because you got a valid assignment by UCC 3, the UCC 3 form, and under 1-202 you have notice and you've been notified.
Exactly. Thank you. That's all I've got. Thank you very much, Christian.
All right, our next caller is from California. Go ahead. You've been unmuted.
Hello. How are you?
Hi.
Good.
Hi, this is Carlos from California.
Yes, how you doing?
Fine, thank you, guys. Quick question for you. Have you heard about Pure Trust?
Yeah. Mm-hmm.
Are they legal, illegal? Do they exist?
Well, I know the IRS likes to punch holes in them, but they're punching holes in them because the trustees are not acting like trustees because they don't know how to administer the trust.
Okay.
Hey, Christian, if I can jump in here, I've worked with Pure Trust for several years now, and no court of law has ever invalidated the authenticity or the legality of the trust, and the IRS themselves have said that they don't recognize pure trusts. That doesn't necessarily mean they don't exist because they're common law contracts.
Right.
But
they just can't see them.
Yeah, they can't see them, and they say that pure trusts have no reporting requirements, and the reason that is because they don't have a federal tax ID number. Now, if you go ahead and take a pure trust and you apply for a federal tax ID number, you've just invalidated that trust, and it's now a statutory trust, and that's the difference between a trust that is incorporated and has a some kind of a tax ID number and one that does not is whether it's a common law trust or a statutory trust, and that's the difference.
Right. All this stuff we've been talking about is really under statutory law, but trouble is this is just the example, because really I'm really talking about a private trust. I'm just giving examples of how to form the trust, because this provides good examples of how to form a private trust, although the information I'm giving is really statutory trust. But it gives you the knowledge that you need, because really I'm talking about private trust.
Right. Now, could going back to foreclosures, Christian, could I have a power of attorney for a home that I want to buy from somebody else? I added myself to the title. I did a land trust so I can hide not hide, but keep it out of the public records. And also, I have a power of attorney. Can I express a trust in that situation?
Yeah, but you got a private trust, you're saying, right?
No, a land trust. Land trust. I mean, I can.
You didn't record it, though, right?
No, land trust are not recorded.
So it's private.
Right.
So who are you going to express it to? You want to keep it private.
Right. Yeah, what I'm trying to do, I'm trying to acquire that property.
Okay, the property has been abandoned, and you got the problem with the successor trust that is a statutory trust in the county, because the previous owner is the grantor and the new buyer is the trustee, and there was a trust formed in the county. So you got a statutory trust that in the county, and you also have a contract or obligations that are attaching to the property. The property is the building that rests on the land. Now, you may have a land patent or a what else they call it? I forgot the other name.
A allodial title?
Allodial title, right. Prior to 33, you had a perfect title, and that was the land patent or the allodial title. But when they took the money out of the system, the trust had to come in and fill the void, and what a trust does also is it splits title. So now the perfect title has been split into two, which is the legal title resting on the trustee and the beneficial title resting on the beneficiary. So you formed a trust by the previous seller, attaching the land or attaching the property into the trust. And you got these contracts with these other obligations that they're holding this stuff in trust, and they got these bonds drawn against these assets that they're holding in these CAFR funds and stuff for the county. And now you got to get rid of these contracts first before you can come back in and cancel the trust in the county, and before you can even merge the titles back into one perfect title.
Yeah, it seems rather confusing. Not confusing, but complicated. What's the easiest way in your what would you do in that position? Let's say, for instance, the home next door, the guy's losing it. He doesn't want to he's going to walk away. Can I come in there and buy him out? I'm going to put myself on that deed and also power of attorney, and I'm going to try to negotiate to the bank or fight with the bank. I mean, does that make any sense to you?
Yeah, they're going to come in by operational law, operating on a debtor creditor, because this is the contract that he's signed into, and you can't come in and re-jump this contract without first this contract being settled.
Right. Yeah. I understand that. Okay, so that's one of them. Now, going back last week, we spoke about the note, right? The bank takes my home, for instance, an example. Takes my home. They must return your note, right? Right.
One, they can't keep the house and the note at the same time, yeah.
Right. Is there a title or law or anything that I can refer to saying, according to this, such and such, I am protected by that, you must return my note if you take my note?
Yeah, let's see, but I forget what it is, because we had a case, cause of action on that. Let's see, where am I going to that? I'll have to think about that in a minute, because that was exactly what you were asking.
Yeah, well, if you want, I'll remind you. Let me ask you something else. I'll remind you. You can think about that for now. What about expressing the trust? Is it going to help us in asset protection?
Say that again. I didn't catch the last part.
Asset protection, like protect.
Asset.
Right.
Well, yes, sure, because, if somebody's got something in the county, I would suggest that at least I would do, I would sell the property that I had that was in foreclosure.
Right.
And I would transfer it into a trust.
Right. That way you get clean title.
Yeah, now the trust has got, I don't own the trust. I'm just managing the trust. I'm not the owner of the trust. The trust is the owner. So, but then I'm going to have to settle the contracts against the previous trust that's in there, because now I'm going to pull it out of the county and put it in my own trust. But I first have to settle all those other contracts that are holding it.
Right. So to create a clean title and to keep it from the bank going back to it. Right?
Yes. Now, once I put it in that trust, now I got all the contracts taken care of. Now it's asset protection.
Right. And you're going to be the trustee in the trust? Because you don't own the trust. You're going to be the trustee, right?
Well, I might want an additional layer of protection against that, because I'm going to go in as authorized representative, representing as the real man, working in a co-position with the trustee, say.
Right.
And I'm going to have that appointment from the grantor as, say, on the Form 56.
Okay. Now, in land trust, the way I have it set up in one of my homes, I have a land trust, and also the beneficiary, it's another trust, another land trust.
Cross-trust them.
Okay.
Cross-lien them.
Right, that's what I do. So they'll never find out who the real owner is unless they keep digging further. Does that make any sense to you?
Well, yeah, if they foreclose on one, the other one has to get paid before the other one gets liquidated.
Right, yeah, that's my point. Right, okay, good. Did you find that note? I'm sorry.
No, I haven't thought in my mind where it's at.
Okay, well.
I'll have to think about it some more.
Yeah, but it does exist, right? I mean, there's
yes, it does. It's actual case site. I have to think where I got it at. And I thought, hey, this could be used exactly for a cause of action to come back in for claiming that they didn't ask for the note, didn't give the note back.
Yeah, because what I'm afraid of, and I can say this because I'm Mexican. What if I go to a Mexican judge and says, "What are you talking about?" See my point? I want to grab something that I say, so according to this number, such and such, it does exist, and we have something to grab onto. You see my point? It's not like I think or I heard. I mean, there's a title or a chapter or anything saying that you must return the note. You cannot keep both things. You pay me, you give me the note, or you give me the house.
Well, that's equitable.
Right.
Really, it comes down to that's equitable.
Okay.
Equity is fairness. That's fairness and just.
Right.
It stands to reason that equity should not allow somebody to have the house and the note at the same time.
Yeah, but
you either got one or the other.
Yeah, so the judge would be. I mean, it's not going to be hard for him, it's not going to be hard for him to understand, or easy to ignore, right? If I tell him he cannot.
See, I don't think we have true equitable courts today, only through trust.
Right.
Because today the courts of equity are nothing more than statutory. Unless you can claim trust, I think that's where the true equity of a court lies.
Yeah, that's the foundation, the trust.
Yeah.
Okay, let me ask you something real quick, and I'll let you go right now because I'm sure somebody else wants to ask something. I got a couple of friends. They wanted me to ask you this. They heard you on some other calls, and they said, could you ask him to describe an accepted for value? I know that's something real simple. Some other guys, I'm sorry. They want you to explain how would you assign or do whatever you need to do to a coupon from an IRS taxes.
Okay.
I know that's simple, but they want to hear it. I'm sorry.
Well, that coupon's actually the payment.
Right.
You see, I'm probably going to, use it as a trust deposit instead as how we've been using it on a debtor creditor. So I'm in a process of changing all that stuff around to where I'm going to treat that whole coupon and the bill part as, I'm going to accept it for value, and I'm going to use it as an asset that I'm going to make a special deposit with. I'm going to make a trust deposit. And a trust deposit is a trust receipt, and a receipt is a record of a payment. So once I made a special deposit, that's a trust receipt. That's been paid. So now under the debtor-creditor stuff, we did an accept for value on the upper part, and we signed the upper part with the we did the acceptance on there. You got to be the grantor on that one. The lower part is going to be on the right-hand side. You're going to sign on, which is the public side. That's going to be the authorized representative. Then you're going to flip it over on the back side, and you're going to sign by, say, trustee, because the signing party is the liable party on the back, just like on a check, and that party has to have access to the funds. So I'm going to sign my name by, all these are restricted signatures. I'm going to sign by trustee on that one, and I'm going to put the EIN number, which is the Social Security number, with the dashes taken out and the one dash put in a particular place in the second place, between the second and third position. And I'm also going to maybe put in the slash and the back side of the number without the letter in the front on the Social Security card, because you have to have the ability to portal into the funds as the trustee, because you're the one that has to have access to the funds to make the payment. And that's the one that signs on the back. He's the one that does the endorsement. He's the liable party, and he has to have the access to the funds.
Right. Where's the best place to send it? Sacramento?
Any one of the, TOP or set-off offices.
Right. Okay. All right, Christian. Thanks for everything, and I'll keep you posted on that other one, that note, taking it back from the bank. I'll remind you next time. Thank you.
Thanks, Carlos.
All right, we got time for one more here. Chick 1836, you've been unmuted. Go ahead.
Hello?
Yeah,
hello.
Go ahead.
Oh, hi, Christian. It's Cynthia from Chicago. Question on the notice that you mentioned, the notice in demand for the note. I actually had the same question as the previous gentleman about finding some either case law or something encoded to find on that. But the notice you mentioned being by UCC 1-202, and then the 3-301 to file that under the assignment. So the notice is the notice in demand, and I'm assuming that you're going to give them. This is post foreclosure, by the way. I'm assuming that you're going to give them at least 30 days to respond. And I agree with you on that SEC information about sending the forms into SEC to exact something on that. But I'm worried about, my question is about the positioning that you would have to put that onto a UCC3. So just this notice gives you the proper authority, for lack of a better word, in order to put this onto the UCC to create that receipt?
I'm kind of not following you at some point.
Okay, you mentioned doing the notice in demand for the note back.
Right.
So if you issue that and it's ignored, let's say you give them 30 days, it's essentially ignored by the bank.
Okay, how are you sending that to the bank?
Notary presentment.
Right.
First of all,
now the notary generates a certificate of dishonor on the last step.
Yeah, that's what I mean by the steps.
They didn't honor your notice and demand for the note back. So now you've got a record. You got a title that's basically going to say, hey, they dishonored.
Mhm.
Now that's the notice the certificate that you're going to put on the UCC1 and claim it first. You're going to claim that title that you created.
Okay.
Now what I'm going to do is I'm going to go with billing, a true bill with that. I'm going to turn that dishonor now into a financial asset, because what is that dishonor worth at this point? Well, it's really has no value on it at all. It's either worthless or it's unlimited worth. There's no value specified on it. And that's where the true bill comes in, because you're going to put a value on it, and you're the only one who can put a value on it because it's yours.
Mm-hmm.
So you put a true bill in there and put your value on what you think that dishonor is worth, and now you got to let that you're turning it into a lien, really. And your lien is going to become your financial asset, your negotiable debt instrument that you're going to create and turn that into a title, and you're going to put all that on a UCC1 and claim it. Now you got a financial asset of a known value that you can put into a trust deposit with a UCC3.
Assigning it over to the trust.
Uh-huh.
Okay, through trust deposit.
Uh-huh.
And I have to look up that. Actually, I was reading that in the other trust law book, getting some clarification on that one. You mentioned on the how can I say, this trust deposit is on a trust that's created, a private trust, though.
Well, it can be a statutory trust.
Oh, it can be?
Yeah.
Mm-hmm.
Under Title 28, 2041, if anything gets deposited, say, into a court, into a trust, there it's within 3 days it must be registered in the U.S. Treasury.
Well, I'm not doing this through a court procedure.
Well, any entity is really a court there they should deposit into the Treasury, really.
Oh, I see.
It should be held in special deposit in the Treasury.
Okay. You mentioned on you mentioned about the IRS presentment, and you mentioned signing the back as trustee. You're literally putting the word trustee?
Yeah, by trustee, my signature, EIN / backside number without the letter.
Gotcha. Okay. That's all I have. I appreciate it, Christian.
All right, Christian, that pretty much wraps it up for tonight. We will reconvene again next Wednesday night at 8 p.m. Eastern Standard Time. Thank you, everyone, for listening and for your great questions. We look forward to getting back together again next week. Have a great week, everyone. Good night.